Markeis McGlockton, African-American male, had arrived at the store with his girlfriend, Britany Jacobs. Britany parked their car in a handicapped spot. Michael Drejka, 47 years old, white male, arrived at the store, and he had an issue with people who illegally parked in handicapped spots. Drejka checking around Jacobs' car and looking for handicap decals or permits. When he didn't see that, he confronted Jacobs. That they got into a pretty significant yelling match. And there was no physical violence, there was no threats. Markeis McGlockton was in the store, learned of the disturbance in the parking lot, so he exits the store. There was no verbalization, there were no statements that were exchanged between McGlockton and Drejka. McGlockton approached Drejka, he really slammed him to the ground is what it is. I mean, this is a violent push. This wasn't a shove. This wasn't just a tap. Drejka had been slammed to the ground. He then reaches, because he's a concealed carry permit holder and he can lawfully carry a concealed firearm, he reaches and takes out his firearm. Drejka fires one round from the gun and it strikes McGlockton right here in the chest. EMS responded. He was taken to Morton Plant Hospital where he was pronounced dead.
And all Markeis did was try to protect his family. He didn't do nothing wrong. He didn't do nothing wrong.
Markeis McGlockton wouldn't be dead unless Markeis McGlockton slammed this guy to the ground. Don't put your hands on people. Don't slam them to the ground. And if you do, you're taking a chance that that person might be a concealed carry permit holder and they might decide that they're in fear and they're going to defend themselves. That's the world we live in. Don't slam people to the ground. People have a right to defend themselves. At about 3:30 yesterday afternoon, Pinellas County Sheriff's Office responded to the Circle A convenience store at 1201 Sunset Point Road in Clearwater. Markeis McGlockton, who's a 28-year-old African-American male, had arrived at the store with his girlfriend, Britany Jacobs. Britany parked their car in a handicapped spot by the store. Markeis and his son, who's 5 years old, went into the store. Another person by the name of Michael Drejka, who's 47 years old, white male, arrived at the store. He lives in the area, was a frequent customer of the store. Somebody who others have said complained about people parking in the handicapped spots. And he had an issue with people who illegally parked in handicapped spots at that store. So apparently Drejka gets out of his car and is checking around Jacobs' car and looking for handicap decals or permits or anything that would authorize them to park where they did. When he didn't see that, he confronted Jacobs. And by all accounts, they got into a pretty significant yelling match. And there was no physical violence, there was no threats, but it was a disturbance, and that they were yelling at each other, and he was complaining about her parking in the handicapped spot. There was another customer there at the store, and the customer went inside and told a store employee that there was a disturbance in the parking lot and that he should do something about it, which was interpreted to mean probably call the police. At that point, Markeis McGlockton was in the store, learned of the disturbance in the parking lot, and it appears that he learned that it was his girlfriend, Britany Jacobs, who was involved in this verbal altercation with Drejka. So he exits the store. He walks out the door, walks straight toward Drejka. By all witness accounts, there was no verbalization. There were no statements that were exchanged between McGlockton and Drejka. That McGlockton approached Drejka. He didn't waste any time getting to him, and then he pushed him. But it isn't just a push. He really slammed him to the ground is what it is. And he pushed him with great force. I mean, this is a violent push. This wasn't a shove. This wasn't just a tap. With his hands, and he slammed him to the ground. So Drejka falls back. And as Drejka falls back, he is on his rear end on the ground. At that point, McGlockton is still a few feet away. McGlockton is facing Drejka, and Drejka is on the ground. And when Drejka had been slammed to the ground, he then reaches, because he's a concealed carry permit holder and he can lawfully carry a concealed firearm, he reaches and takes out his firearm. At that point, McGlockton is still, again, a few feet away. He's facing Drejka. Looks like he's starting to turn a little bit, maybe as we would call blading, which is kind of at an angle, but he's not turned away. He's still facing. And at that point, Drejka fires one round from the gun and it strikes McGlockton right here in the chest. McGlockton then grabs his chest and retreats back into the store where he collapses. EMS responded. He was taken to Morton Plant Hospital where he was pronounced dead. Drejka, after he shot McGlockton, took his firearm, put it in his car, and waited for law enforcement to respond. Drejka was cooperative, and during the interview, what he claimed is that he had a verbal altercation, he was approached, he was slammed to the ground, and that he was in fear. And he felt, after being slammed to the ground, that the next thing was that he was going to be further attacked by McGlockton. He was focused on McGlockton's lower body, really couldn't see his hands, but he felt that the next thing was that he was going to be slammed again and going to be struck again, and that he was in fear. So that's Drejka approaching Jacobs. And you can see he's looking around the car, and he's looking for the handicapped permit decal. Okay, so this is McGlockton coming out. So he's getting ready to push him, and then the shot's going to be fired. And right here. If you count it between the time the Drejka goes to the ground and the time he shoots, it's a count of 4 seconds. It's a count of 4, no more than 5. It's a very short amount of time. What he claims, and you can tell, it's a violent push to the ground. This isn't just a shove. I mean, he slammed him to the ground. He said when he's on the ground, because he's in fear, that the next thing that's going to happen is he's going to be reattacked by McGlockton, and he felt that he was at peril. He needed to shoot to defend himself. McGlockton was still standing there. He was still in front of him. He had the ability, the capability to do again, or worse, what he had already done by pushing him to the ground. As I said, there's no verbalization between either McGlockton or by Drejka during this. The law on stand your ground is clear. The Florida legislature has spoken on this. That is a largely subjective standard. This is not an objective, what I would do, what you would do, what the public would do, what somebody else would do. This is more of a subjective standard. The person's subjective determination of the circumstance they were in, the fear that they had, is relevant to the determination of whether they're justified in the use of force. So under these circumstances, where you have somebody that is unprovoked, slammed to the ground like that, and his statement that he believed that McGlockton was going to come back at him, and he fired in a very short amount of time, a few seconds, 4 seconds probably, somewhere in that range. That is within the bookends of stand your ground, and within the bookends of force being justified. The immunity that people are granted under the stand your ground law is just not an immunity from being charged, not just an immunity from being convicted, but it is an immunity from arrest. And I'm going to read this to you, and here's what it says under paragraph 2. A law enforcement agency may use standard procedures for investigating the use or threatened use of force as described in subsection 1, but the agency may not arrest the person for using or threatening to use force unless it determines there is probable cause that the force that was used or threatened was unlawful. So we're precluded from making an arrest in this type of a situation. Then it goes on to say that the court shall award a reasonable attorney's fees, court costs, compensation for loss of income, and all expenses incurred by the defendant in defense of any civil action brought by the plaintiff if the court finds that the defendant was immune from prosecution. So, 1, we have to follow the law. 2, if we don't follow the law, we're civilly liable for not following the requirements of Florida stand your ground law. Importantly, the legislature this session changed the framework for stand your ground. The framework for stand your ground used to be that the defendant had to raise stand your ground as a defense, and the defendant had the burden of proving that they were entitled to immunity under stand your ground. And the legislature changed the law. The law now is that the state attorney has the burden of proof by clear and convincing evidence that the defendant, the shooter, is not entitled to stand your ground. Nowhere else is there anything like this in criminal law where somebody asserts something and the burden then proves to the other person or shifts to the other person. The law is changed dramatically because you've got a situation here where stand your ground allows for a subjective belief by the person that they are in harm's way, they're in fear. In this case, this guy was slammed to the ground. In very short order, he felt it necessary, felt it necessary to defend himself because he felt he was going to be attacked again. And in order for him not to be justified, you have to take it outside of those bookends. We are precluded from making an arrest unless we have probable cause that the person committed a crime, and we don't have probable cause here of that. And even if we were to charge, or if the state attorney were to charge, all he has to do is say, stand your ground, and then the state attorney has the burden of proof by clear and convincing evidence at a stand your ground hearing that he is not entitled to stand your ground immunity. And that's a very heavy standard, and it puts the burden on the state. So under these circumstances, we cannot make an arrest. We're going to refer this to the state attorney's office. The state attorney's office will review it and apply the law to the facts and make a determination as to whether something should be charged. Before stand your ground, a case like this probably would have a different outcome. As you can see in there is a pause, even if it's only for a couple seconds. There is a pause between the time Drejka hits the ground and he shoots. That pause gives me pause. That pause gives me some concern, and it goes back to what I said when I opened. Just because you can doesn't mean you should. And we don't get to substitute our judgment for Drejka's judgment. My question is, and what I have to do is make a determination, applying the law to the facts. Is he within the framework of what the law allowed him to do? Does this law create a situation potentially where people shoot first and ask questions later? Well, you can have that discussion. You can have that debate. I don't make the law. We enforce the law, and I'm going to enforce it the way it's written, the way the legislature's intended for it to be applied. Others can have the debate about whether they like it or not. So this will go to the state attorney. Drejka will not be charged. He will not be arrested by us because we're precluded from effecting an arrest. The state attorney will view it, and either he'll concur or not.
So you talked about that pause when he pushed him to the ground. There you counted 4 seconds, Sheriff. But he's not coming after him during that pause.
Doesn't matter because this guy's on the ground, and no matter how you slice it or dice it, that was a violent push to the ground. That was a slam to the ground. So he pushed him to the ground. He violently goes back on the ground, and he's sitting there. He takes the gun out, and what he's seeing and what he's saying in his mind is the next thing he's thinking is this guy's going to come at me again, and he fires. Is that within the bookends of a reasonable belief on his part under those circumstances of that time? Yeah, it's within the bookends. Now, you could say, is it on the fringe of the bookends? I don't know. I'll leave that to others to judge. But is it within the bookends? Is he legitimately, could he be in fear after that violent slam to the ground? Could he be in fear that the next thing is that this guy's coming at him again when the guy's standing right there and he's standing right there like this? Yes, he could. He has said, hold him at gunpoint, and you could cut that both ways. He could hold him at gunpoint and not fire. Yeah, he probably could have done that. But also, the fact that he's holding him at gunpoint could also cut towards his legitimate fear. The guy didn't turn around and run away real fast. And the guy didn't do anything. He said, hey man, we're good or something. He didn't do any of that. It cuts towards this guy's belief in his mind he's going to be harmed again, and he had to shoot to defend himself. And those are the facts, and that's the law.
But there were no direct words between the two men that you know of.
They didn't, no. And I'm not going to get into altering the facts, because altering the facts alters the outcome. But if you were to engage in that exercise, and you were to alter the facts further to the left or further to the right, and you were to change this scenario, it could have a different outcome. And if there were an exchange of information, and if the exchange of information was Markeis McGlockton making threats to him, verbalizing and saying things that buttressed his belief that he was in harm and imminent harm, then that cuts more towards justifying the shooting. If Markeis McGlockton was saying stuff like, hey man, we're good, and forget about all this, then it cuts the other way. If you have longer time, like 8 or 10 or 15 or 20 or seconds, and McGlockton had turned away, well then that changes the outcome. But we cannot change the facts. The facts is that he approached him, slammed him to the ground, and within about a 4 count, he fired. No words were exchanged. We've got to use only the facts, and the facts are clear based upon video and eyewitness accounts.
Speaking to the owner of the store, he tells us that the man who fired the shots is a nuisance there, that he's caused problems in the past.
What's material here is what happened at that instant. We have to recognize if Markeis McGlockton hadn't walked up to him the way he did and slammed him on the ground, we wouldn't be here having this discussion either. So what's relevant is not whether this guy's a good guy, nice guy, or whether he's a jerk, or whether he's a thorn in people's sides, and what he's done, whether it's 3 weeks ago, 3 months ago, or 3 years ago. What's relevant, and the only thing that we can look at here is, was he in fear of further bodily harm because of what Markeis McGlockton did, and was he in an ability and have the capability to carry it out? And the answer is yes. That's what we got to look at. I'm not saying that this guy, he might well be a thorn in people's side. He might be a jerk. He might be all of those things. That doesn't matter. That doesn't matter. What matters is, did McGlockton slam him to the ground? Yeah, he did. And was this guy put on his rear end? And was McGlockton standing over him and in a position to do what he thinks McGlockton was getting ready to do, which was to come at him again and harm him further? Yes. And does Florida law allow you to defend yourself and stand your ground? It does. That's what the Florida legislature has said. Our job and our role is not to substitute our judgment for the law and what the legislature has crafted as a framework, but to enforce it equally and fairly as we're required to do. I'm not saying I agree with it, but I don't make that call.
Do you disagree with it? Would you just come out and say you disagree with it?
Well, I'll say this. Just because you can doesn't mean you should, but I'll also say this, is I'm not going to substitute my judgment for Drejka's judgment sitting on that ground after having been slammed to the ground either. And from his perspective, sitting there on the ground within a few seconds, literally, because he took the gun out and he made a decision. So it really doesn't matter what I would have done or what anybody else would have done. Would I have done something different? There's a difference between, arguably too, what a law enforcement officer would do. And this guy's not. He's just a citizen. And he felt he had to defend himself.
Sheriff, where does the law come into play where he's running out thinking that his family is being threatened and he feels like he has to defend his family?
There's no evidence of that. And again, that's what you got to be real careful with. You can't, and I get the tendency, but you can't impute facts that don't exist. And there is no evidence, no testimony, no witness account that his family was in harm's way at all. It was purely verbal. And by all accounts, there was not even any threats. They're just arguing back and forth about the handicap spot. I'm guessing, but we can't unfortunately talk to Markeis because he's deceased, as to what was going through his mind. He probably didn't like the fact, and I don't think it takes a giant leap to get there, he didn't like the fact the way this guy was talking to his girlfriend. But Markeis shouldn't have gone up and slammed him to the ground either. He should have said, look, man, knock it off. He didn't have a right. Markeis engaged in unlawful conduct himself. Markeis should not have gone up and slammed this guy to the ground. Markeis wouldn't be dead if Markeis didn't slam this guy to the ground. So, Markeis has got skin in this game too. And the reason why it makes it justified and within the framework of stand your ground is because of what Markeis did. It's really sad. And again, we can have a discussion about what we would have done or what the law would be, or what we would have done under the law prior to stand your ground, or prior to even the change that puts the burden on the state and makes it a clear and convincing evidence standard. We can have those hypothetical discussions all day long, but I don't live in a hypothetical world. I live in a world of what's the law, what are the facts, and how are we going to apply it as directed? And that's what we have to do.
Are you frustrated with, especially this change now that puts the burden of proof on the state attorney?
People should be able to defend themselves. They should. There are times, and I can give you, again, we can come up with situations and scenarios where I do believe that stand your ground has its place. So as an example, before stand your ground, if somebody's walking in the mall parking lot and somebody comes up and attacks them, is that they're required to make an effort at least, or reasonably retreat before they can use force. I don't think if somebody comes up to you in the mall parking lot and tries to rob you, that before you can use force and defend yourself, that you should be required, there should be a requirement in the law to retreat first. Then you get the other end of the spectrum, which, somebody can certainly make the case that maybe this guy could have handled this differently. But, so that's why you got a range and you got bookends, and you're going to have things that fall toward one end of the bookend or the other that aren't squarely in the middle. I think there's an argument this probably falls towards maybe one end of the bookend, but it doesn't take it outside the bookend, and it doesn't mean that you throw the baby out with the bathwater. And I see where there can be benefit and the right thing for people to be able to protect themselves. Look, nobody has a right to harm somebody else. Nobody has a right to commit a crime against somebody else. And no matter how you slice it, dice it, or otherwise, you got to come back to is that Markeis McGlockton wouldn't be dead unless Markeis McGlockton slammed this guy to the ground. Don't put your hands on people. Don't slam them to the ground. And if you do, you're taking a chance that that person might be a concealed carry permit holder, and they may decide that they're in fear and they're going to defend themselves. That's the world we live in. Don't slam people to the ground. People have a right to defend themselves.